كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. My dear brothers and sisters, all of you guys who are taking the BA course at Wise University, Allah bless you all, keep us all in your du'as as well at White Thread, who are providing all of these lectures. So we start with lecture number 9 today, inshallah, of the Masail and rulings related to the Islamic judiciary. So as you know, we're still in the midst of Kitab al-Shahadat, about the various different witnesses and how witnessing takes place. So now today we're going to be finalizing this chapter, completing pretty much most of the rest of it, and moving on to another one eventually, inshallah. So the next point here that Imam Quduri makes after the discussion that we had about the discrepancy in somebody being killed and the witnesses in terms of that we did in the last lesson. So today we're dealing with وَلَا يَسْمِعُ الْقَاضِي الشَّهَادَةَ عَلَى جَرْحٍ وَلَا يَحْكُمُ بِذَلِكَ. Kind of vague statement, but Imam Maydani clarifies it. What he means is that, let's just say that the claimant puts in a case, he has a lawsuit, and his opponent, the defendant, puts in criticism, forwards criticism, disparaging criticism regarding the witnesses that the claimant has brought in, and even provides evidence to the fact that they are fasiq, right? That they are transgressors. Now usually if somebody is proven to be a transgressor, you can't use them as witness. Now in this case, because there's a conflict of interest here, yeah, the defendant does have the right to say that they need to be verified, but he can't, they personally cannot do the disparagement or the criticism. The judge can't listen to them. He can take the cue from them to have them checked out, that's for sure, but he has to do his own investigation. The judge has to do, the judiciary has to do their own investigation, right, to find out what the situation is, and he can't listen to what proof is being presented by the opponents. So if they are then found to be upright and adil according to, you know, the judge and according to his system, then he can listen to them and judge accordingly. Otherwise he has to abandon them as well. So yeah, so those were the kind of discussions we're gonna have, and then it carries on to some other discussions today. So we'll delve inshallah right in. Assalamu alaikum. So yeah, we are now moving on to ash-shahada bit-tasamu', which basically means that can you bear witness, can you give testimony for something that you haven't seen but you have heard about? How does that work out? So Imam Quduri is saying, وَلَا يَجُوزُ لِلشَّاهِدِ أَن يَشْهَدَ بِشَيْءٍ لَمْ يُعَايِنْهُ. It's not permissible for the witness to testify to something that he hasn't seen, because he's, in Arabic the word is shahid, and he's giving shahada, and the whole idea of shahid and shahada comes from the concept of mushahada. That's where this word is derived from. That's where the concept of shahada is derived from. Mushahada, which means to observe, is basically a way of gaining knowledge of something. So if he doesn't have direct knowledge of it by observing it and seeing it, then how can he say that yes, that is exactly what took place, because there's so much ambiguity in that. Yes, there are some things that they've made exception to, right? A person is allowed to bear witness to certain things that commonly become so well known and widespread that they're usually not a mistake. So in that kind of case, a witness can be brought to say, yes, I know him to be his child, right? For example, you know, if you look at our own case where there's so many people we know to be children of so-and-so, brother of so-and-so, and you've known that all of your life, everybody thinks so. You don't go and check their birth certificate or do a genetics test or something, right? But it's something that is the case. People just know about it and they take that. So that's why he's saying illa nasab, except the cases of genealogy, ancestry, wal maut, death, right? When it's commonly known that somebody's died. When nikah, nikah obviously marriage, dukhul, consummation of the marriage, wa wilayat al-qadi, that such and such a person has become has been given the position of a judge. فإنه يسعه أن يشهد بهذه الأشياء إذا أخبره بها من يثق به. So he has the scope, a witness has the scope to testify to these things if as long as he's been informed of these things through somebody reliable. And qiyasan, by default, it should not have been allowed, but this is a juridical discretionary ruling of istihsan, essentially, right? Because Imam Maydani explains لأن هذه الأمور يختص بمعاينة أسبابها الخواص من الناس ويتعلق بها أحكام تبقى على انقضاء القرون والأعمام فلو لم يقبل فيها الشهادة بالتسامح لادعى إلى الحرج تعطيل الأحكام. Many of these things, he's saying that some of these matters, the actual cause of these things, very specific people would be able to figure them out, like to really figure out 100% that somebody's child. You'd have to genetic test and things like that, and so on. So, however, there's lots of rulings that are related to these things, and if we made it very strict that you had to have 100% proof in this regard, it'd make life very, very difficult for everybody in a society. So, however, there's going to be the way the witness is going to say something. That's why Hidayah mentions that وَإِنَّمَا يَجُوزُ لِلشَّاهِدِ أَن يَشْهَدَ بِالْإِشْتِهَارِ, that the witness is allowed to testify based on the prevalence and the widespread knowledge of that idea. وَذَلِكَ بِالتَّوَاتُرِ, and that has to be so widespread that it would be assumed that this can't be a lie, right? Or it has to be based on a report from somebody who's absolutely reliable, right? So that's what he's adding to that. Another stipulation that somebody's put up is وَيُشْتَرُطْ أَن يُخْبِرَهُ رَجُلَانِ عَدَلَانِ. It can't be just one person that has told him this. It has to be two upright people that have informed him that such and such a person has died before he can say, yes, I can testify that he has died based on that. Or one man and two women must have told him, right? In fact, they say that when it comes to death, there's a lesser, that they allow a lesser quantum, which is just one person, one male or one female telling him, as long as they're reliable, that yes, so-and-so has passed away, right? Because sometimes, and of course, this is not after 10 years after the person has died. Everybody would know that. This is like, let's just say that somebody has just passed away, like yesterday, and only one person was with that individual, one woman was with her grandmother, so it's only that woman saying so. That would be sufficient, they're saying here, because sometimes there's only one person by the deceased when when they died. Now in this case, there's a lot of other detail here of exactly how they will provide this shahada, so you can check that out in other books, right? We'll move on to وَالشَّهَادَةُ عَلَى الشَّهَادَةِ جَائِزَةٌ فِي كُلِّ حَقٍّ لَا يَسْقُطُ بِالشُّبْهَةِ. Witness on a witness is permissible regarding every right that doesn't drop off due to any kind of doubt. So if it's a sensitive right which needs 100% unambiguous or definitive evidence, then it's permissible to give a witness upon somebody else's witness, right? And again, this is based on istihsan, juridical preference, just to make life easier, because there's a huge need for this, right? Because sometimes what happens is that the person who originally saw the incident or the problem, he won't be able to come in to testify due to whatever reasons. It happens a lot, right? So if it was not permissible to say that, look, I know that he gave, we discussed this issue before, where they would give witness to somebody else and you would listen and they would make you their representative, right? It means that a lot of people's rights would be lost, and there wouldn't be a just system that we could then rely on. So that's why this is allowed, right? This has been allowed, that if, as long as somebody's testified somewhere, not in front of the official judge or formally, but then you've heard it and he's made you the responsible person for it, the deputy for him, representative for him, then it's completely fine, even though there's obviously going to be that slight doubt in there, but that's tolerated in this case. That's why you just have to check out each person who is saying this, as long as they're upright. So this person who's going into court to deliver this witnessing, this testimony, that obviously that person has to be correct. And this system is such that if anybody has ever seemed to be, made a mistake in that regard, major blunder, lied, then obviously they won't be accepted in the future. That's why this would only be allowed in non-hudud or qisas issues, because in hudud or qisas they're very strict as to what they will take. So you can't do shahada on a shahada, right? Witness on a witness in the case of hudud and qisas, because those things are so sensitive that any doubt and they can't be implemented. Now, when it comes to this, then what numbers do we need, for example? So he's saying, what does tajuzu shahadatu shahidaini? So it's permissible for these representative shahids, you can call them, right, this second level witnesses, to be either two male again or one male and two females upon the witnessing of two males, right? So yeah, so that's completely fine. That's what he's saying. وَلَا تُقْبَلْ شَهَادَةُ وَاحِدٍ عَلَى شَهَادَةِ وَاحِدٍ. So obviously, if there's only one original witness, and then he puts somebody, a trustworthy person, as his representative to listen to his witnessing, and he makes him his representative, then that guy goes, that's not going to be enough, because there's only one person. You need two people ultimately. Okay, finally, towards the end of the chapter, he decides to tell us how they will come into court. As I said, it's a bit disjointed, the chapter. He's already discussed the wording that the witnesses have to use, but then now he's talking about how a person who's the representative of another witness, what kind of wording he has to use, right? So it's correct to be put into this place. He says, وَصِفَةُ الْإِشْهَادِ, the way to get somebody else to be your representative as a witness is أن يقول شاهد الأصل مخاطبا لشاهد الفرع اشهد على شهادتي أني أشهد أن فلان ابن فلان أقر عندي بكذا وأشهدني به على نفسه, right? So it's going to be words like that the original witness is going to say, addressing the representative witness, that you bear witness upon my bearing witness that I have witnessed. I hope you didn't get lost in that, right? Let me do that again. So the original witness, right? Now follow this. He will say, addressing his representative, who's going to become a witness, that you bear witness upon my bearing witness that I witnessed such and such a person confessing to me, confessing in front of me with such and such, that he owes the other person £1,000, for example, and he has made me witness upon himself, right? So you would do that. That is how a witness would make another witness to represent him, essentially, right? Right. If he doesn't say ashhadani ala nafsihi, that he's made me witness upon himself, that's fine. The last part is not necessary, because this original witness, he doesn't have to say that that person who confessed has also made me witness upon himself, because he's seen him confess to that, right? He's already seen him confess to it, so the confessor doesn't have to tell him to be a witness, because he's already seen him confess and he's already witnessed it. So that last phrase was extra. He doesn't have to say that, right? So essentially, person A is the one who heard person B, right, confess to owing a loan. So person A will now tell person C that you have to become my representative, that I bear witness, that I testify that I have heard this person B confess to £1,000 debt that he owes, right? So you bear witness for me, right, that he has made me a witness, that he has made person A a witness. That last part is not necessary, because just by the mere fact that you heard him or saw him, you become a witness anyway. So he doesn't have to make you, he doesn't have to make the original person a witness, because he already witnessed it anyway. He doesn't have to say that you be my witness. If I see an event, I'm the witness already. They don't have to tell me that you're a witness. Right? And that's quite clear. Okay. Now, the representative, وَيَقُولُ شَاهِدُ الْفَرْعِ, when he goes to testify in court, right, as a representative of that, right? Remember, he's going to be the witness now, right? But he's a second level witness, obviously. So when they call him the شاهد الفرع, ويقول شاهد الفرع عند الأداء لما تحمله أشهد أن فلانا أشهدني على شهادته أنه يشهد أن فلانا أقر عنده بكذا وقال لي اشهد على شهادتي بذلك. Now this one is quite straightforward. He will go into court and say, I bear witness that so and so person, meaning the first original witness, has made me a witness upon his witnessing, that he witnesses, that first person witnesses that such and such a person, maybe the defendant or whoever he is, right, has confessed to him that he owes such and such, and then he has told me and instructed me that you bear witness upon this witnessing of mine. So it's quite a formal statement. But again, if you have it written, it'll be quite easy. I mean, you don't expect that witnesses would have to memorize this. I mean, they could easily have this written and they could read it off as long as they're understanding what they're saying. Right? So the reason why it has to be said in that much, that I bear witness that he has made me a witness, to say that he has witnessed that person confessing to this much loan or whatever, and he has told me that you go and bear witness upon my witnessing of this. So it's quite a formal statement, as you can see, because it's necessary for the person to give a witness and to mention that it's the original person who is the original witness, and he has made me a witness. So essentially there's three things going on there. Now some judges would have lengthy, I mean, again, it depends on judge, but these basic elements have to be fulfilled. Some judges might have a longer statement that they need to make, or a shorter statement, as long as it's quite clear that you are doing it on behalf of another person and it's very, very formalized at every level, then it's completely fine. This much, he says, is kind of the moderate amount, because some people have longer statements while others have shorter statements. The best of these is this. Right, what would a shorter statement look like? As in Ad-Durr al-Mukhtar, he said that ishhad ala shahadati bikadha. So the first person would say, you just bear witness upon my witnessing of such and such an event. That would be the shorter form. Then the representative witness would say, ashhadu ala shahadatihi bikadha. I am bearing witness, I am testifying to his witnessing such and such a event. So that much is enough, completely fine. وعليه فتوى السرخسي وغيره ابن كمال وهو الأصح. So this, he says, Sarakhsi's fatwa is on this one, that this is sufficient. Ibn Kamal and others have related this as well, and this is the soundest opinion, as mentioned by others as well. Right, now, when is this representative witness, this deputy witness, secondary witness, whatever you want to call him, when will his statement and witness be accepted? ولا تقبل شهادة شهود الفرع إلا أن يموت شهود الأصل أو يغيب مسيرة 3 أيام فصاعدا. When is it allowed for a person to deputize somebody like that? Because remember, it's obligatory for a person to go themselves usually. So they're saying that the deputy witness's witnessing will not be accepted unless it is extremely difficult for the original witness to be present. That could be because they've died, but they'd made another witness, they'd made the deputy witness before they died, but they died by the time that he had to go to court, for example, they had died. Or he's on a journey, he's on a business trip, he's on a trip somewhere else that is too difficult for him to get back for. He's beyond 48 miles or somewhere like that. So Imam, this is the primary view, but Imam Abu Yusuf, he says that if he's not there, that's enough. He doesn't have to die, he doesn't have to be so far, he's not in town, that's enough, right, for the deputy to be allowed to take to appear in court on his behalf, right? Basically saying that if he's so far off that it's difficult for him to come back home at night, right, he's that distance away that it's quite a difficult thing to come back and then to have to go back, then that would be sufficient, right? But the main opinion is above. Or the other reason it might be is that he's very sick, so he can't get out of his house, he's got huge stomach issues, he's got another bed-bound issues, he just can't come out of the house, or whatever the case is, right? So he's not able to come to the gathering. The doctors would say that it would be incorrect for him to do that. Then in that case as well, it would be allowed. Now he moves on. فَإِنْ عَدَّلَ شُهُودَ الْأَصْلِ شُهُودُ الْفَرْعِ جَازَ. If the original witnesses were considered to be valid and upright witnesses by the deputy witnesses, that's enough. That would be enough. However, because remember, the person appearing in court is person B, for example. The original witness is not around, so the judge, can he just go by person B, what he's saying, that yes, I trust that person A is fine, right, and I justify him, I validate the original witness? Is that enough? So he's saying yes, that should be enough. But if the deputy witness is not willing to say yes or no, to either disparage, criticize, or validate, and they stay silent in that regard, they're willing to give witness, but they're not willing to say what the state of uprightness is of the first original witnesses, then the Qadi has to check them out, the Qadi has to investigate them. Now, you might even have a situation where the second witness goes and witnesses on behalf or from the first witness, and then the first witness says, no, we did not make you a witness. So that obviously would give rise to that kind of a problem. So وَإِنْ أَنْكَرَ الشُّهُودُ الْأَصْلِ الشَّهَادَةَ, right, بأن قالوا ما لنا شهادة على هذه الحادثة وماتوا أو غابوا ثم جاء الفروع يشهدون على شهادتهم, right? So if they say that, if the original witnesses belie the witnessing and saying that we have no such witnessing, it's not a testimony we've given, and then after that they die or they disappear, right? But then the deputy comes and gives the witness there, right? Then obviously you can't accept that witness. You can't accept that secondary witness. That's obviously very, very clear. The similar is if they say that we are witness, but we did not make you the witness. We did not make this secondary person a witness. And then after that they've died or they've disappeared, right? You can't accept this secondary witness now, right? Because it is necessary for the first witnesses to make them and authorize them as witnesses. Otherwise there's nothing, because they're carrying the load from the first to the second. If they haven't allowed them to and delegated them, then it's just not going to work. And then that means that there is actually a ta'arud, which means a conflict between the two parties. Okay, now to end this chapter, the author brings a few other things, right? He's saying that, let's just say somebody gave witness and then it was discovered that they were false. They lied. They made up something. What are we going to do in that case? So, وَقَالَ أَبُو حَنِيفَةَ فِي شَاهِدِ الزُّورِ أُشَهِّرُهُ فِي السُّوقِ. It's quite severe. Imam Abu Hanifa would say regarding a a false testifier, right, that I would essentially publicize him in the market. I would punish him by essentially calling out in the market. This is what they used to do in those days. Now you could just put it online, right, and put it on the news. Actually, this is what they would do nowadays. And there was no news like that. The news was that you sent a caller, an announcer, a herald into the market, and they would just say, this is what has happened. Okay, that was the media of the day. So in this case you say بأن يبعثه إلى سوقه إن كان سوقيا أو إلى قومه إن كان غير سوقي بعد العصر أجمع ما كانوا ويقول المرسل معه إنا وجدنا هذا شاهد زور وشاهد زور فاحذروه وحذروه الناس كما نقل عن القاضي شريح. So this is something that Qadi Shuraih, the great Qadi in Kufa, would do as well. Right, so they would send him. So if he's a person of commerce from the market, they would send him to his, mall or shopping market or whatever it is, or to his people if he's, if he's not one of those, to his area. Essentially, after Asr is usually the busiest time where everybody is just trying to buy their bread or whatever it is they need for the night, before everything closes, before they go home, they're coming back from work. That's the most busiest time. They would send them at that time, ajma'a ma kan, when it's the busiest, and then the herald who's been sent with him would say, we have found this person to be a false witness, he's told a lie essentially, and be careful about him, beware of him, and let other people know about him, and let other people be careful about him as well. And this is exactly how it was transmitted. This is what Qadi Shuraih would do as well. Imam Abu Hanifa then says, وَلَا أُعَزِّرُهُ بِالضَّرْبِ, I would not beat him, I would not flog him. So I would not give him any other physical discipline of, striking him. لأن المقصود الانزجار, because the whole objective of this is that he desists from this in the future, and other people desist as well, and people don't use him, so that it becomes kind of a humiliation. ويحصل بالتشهير, that's become known by publicizing this. I think nowadays what it would do is they would probably put it on the local station, and if it was a global issue, if it was a countrywide issue, it would be on national television or national media, right? Radio, etc. That's the way they would do it. They didn't have radios and TV in those days for news, audio visual news. That's the way it would be. In this case, that's what they do. They put notices, for certain things in the market. In the local newspaper, or they put it on the lamppost. This is the kind of stuff that they would do. But now we've got the media anyway. But ربما يكون أعظم عند الناس من الضرب فيكتفى به. No need to beat him up, because this is probably a worse punishment, right? This is a worse punishment probably than even striking him, to beat him up. This is much worse than that. For him to lose his credibility, for him to be humiliated like that, is probably worse. Now you might say that if he's such a person, why did they even take him in the first place? Well, first, he was fine, so he's not really a person who doesn't care for what people think. Clearly, if he was that kind of a person, he would not have been able to be a witness in the first place. Somehow he got paid off or whatever to lie, or he did it out of love for his friend or whatever, right? That's why. And then he gets in trouble. He thought he was going to get away with it. He got in trouble. So this is going to be worse than having him beaten up or some other, punished in some other way, right? وقال أبو يوسف محمد نوجعه ضربا. They say no, this person is so has done something so serious, Imam Abu Yusuf and Imam Muhammad Sahibain, that we're actually going to discipline him physically, right? ونحبسه, and then after that we're going to also imprison him حتى يحدث توبة, until he makes a clear, sincere, repentance. Nasafi, Burhani, Sadr Sharia, they've all taken Imam Abu Hanifa's opinion. Now, how is a person discovered to be a witness that has lied? I mean, I guess there's some very simple ways of doing that, where it becomes quite clear that the evidence is found out later that it's quite clear. So, but anyway, he's discussed that at the end. Actually, Imam Maydani has discussed that. Imam Quduri has not discussed that. كيف معرفة شاهد الزور ثم شاهد الزور هو المقر على نفسه بذلك. One of the first ways is that he confesses himself that, I lied down there. He confesses in front of other people, and that becomes known, right? So, or he goes and officially says it, he feels bad, he regrets what he's done, so he goes and he confesses that, that was a mistake I made, right? إذ لا طريق إلى إثباته بالبينة لأنه نفي للشهادة والبينات للإثبات. You can't use, he says there's no real path to establish that as to what he said with a proof, because that is negating his, that would be to negate his, officially that would be to negate his witness. And usually we use proof to establish something rather than negate something. That's a very interesting point, right? If there's somebody who gave witness, who gave a testimony in court of a person killing somebody, right? And then suddenly that, oh, you know this guy called Saleh, right? He killed Zubair, and then suddenly they see a few days later Zubair is actually fine. He was just sick. So clearly that's another way that it's going to become clear that this guy lied, right? And that's obvious. There's no doubt about that one. That's an obvious way to find out that he lied about that. Now, on the other hand, if the guy said, look, أخطأت في الشهادة أو غلطت, that, you know, I made a mistake. I made a blunder. I made a mistake. I misunderstood. I misconstrued it, right? I got it wrong. Then in that case, he's not disciplined. Of course, if he keeps making that, and there's lots of cases that are happening with that, that's going to be an issue. Okay, now that was the end of that section. The next section now is Kitab al-Ruju' an al-Shahada, which basically means that, let's just say somebody did witness, and then after that they decide that I can't be a witness. There's a, you know, for whatever reason they decide to retract their testimony. So this is retracting their testimony. Ruju' an al-Shahada, right? So they take their witnessing back. How does that happen? What exactly does that happen? So saying إذا رجع الشهود عن شهادتهم, if they retract, if the witnesses retract their witnessing, they say that, yeah, this is different. There's going to be a different case if they say, no, we did not witness. We did not give this testimony. That's different from saying, yes, we gave it, but now we retract it. قبل الحكم بها. And of course, if this is before any judgment was made, they gave witness, but before the judgment was made, maybe the case was adjourned for a while, they decided to retract. سقطت شهادتهم. Then it's quite a simple process that their testimony would just be dropped, right? It's like there hasn't been anything, because nothing has been judged according to it, right? And the judge can't take their witnessing anymore because they've just retracted it. They also, do they have a penalty for this? No, they haven't caused any harm yet, right? Because neither on the claimant, neither for the defendant, because no judgment had been made, right? However, if a judgment had been made by the judge based on their testimony, then they retracted, لم يفسخ الحكم. Interestingly, the judgment would not be cancelled. The judgment would not be cancelled. By them retracting, the judgment will not be cancelled, because it's going to be seen that, see, remember, the judicial process is a process. Once the judge has seen, okay, this is the claim, these are the two witnesses, done. It's a done deal. Now they come back and say something different. They're trying to cause a problem, and judgments do not break, are not cancelled so easily, right? They're quite strong once they're done, because they don't take them lightly. When they do them, they make them, it's done. It's very difficult to cancel them afterwards. So now in this last session, in our summary, to finish this off, however, وَإِنْ حُكِمَ بِشَهَادَةٍ ثُمَّ رَجَعُوا لَمْ يُفْسَخِ الْحُكْمِ, as they mentioned, because really it's just a contradiction now. So it's been ratified. Now they come and say something else. It's like anybody else saying. It's just like that. It's going to be treated like that. فَلَا يُنْقَضُ الْحُكْمُ بِالْمُتَنَاقِضِ, right? وَلِأَنَّهُ فِي الدَّلَالَةِ عَلَى الصِّدْقِ مِثْلُ الْأَوَّلِ وَقَدْ تَرَجَّحَ الْأَوَّلِ بِإِتِّصَالِ الْقَضَاءِ بِهِ. Now you've got two statements of this. The first one, which they said, they testified to something, now they're testifying to something else. However, the first one is already a judgment on it, so that's become ratified. There's no way to now, you see, it's like they've got two equal statements, one saying one thing, one saying the opposite thing, which one do we go with? There's no preference for either. However, the first one was done under a judicial process and it was accepted, so that's going to remain stronger, right? And that is going to continue. وَوَجَبَ عَلَيْهِمْ أَيَشْهُدُوا ضَمَانُ مَا أَتْلَفُوهُ بِشَهَادَتِهِمْ. Right? However, while the judicial process has happened, there is going to be some kind of repercussion for them. So let's just say that they had witnessed, they had provided witness of a person owing somebody something, and then they go and retract saying, no, he actually did not owe him £500. But the guy had to then pay £500, right? Already. So now they would be liable for that. So وَوَجَبَ عَلَيْهِمْ يَشْهُدُوا ضَمَانُ مَا أَتْلَفُوهُ بِشَهَادَتِهِمْ. Upon these witnesses, after they've retracted, after a judgment was made, they would have to pay a penalty for what they had essentially, what they had caused as a loss through their original witness. Because now they are essentially, while it's not going to be in court, while it's not going to spoil that case in any way, they have now confessed to themselves that yes, we, by our original witness, we caused this to happen, right? So we are the ones liable for this excess, this person having to pay so and so, right? So they're also claiming that this judgment, essentially what they're claiming is that this judgment was wrong ultimately because we were wrong. Now, that can't affect that, but it can affect them because now they're confessing. So that's why وَدَعْوَى إِتْلَافِ الْمَالِ عَلَى الْمَشْهُودِ عَلَيْهِ بِشَهَادٍ فَلَا يُصَدَّقُونَ فِي حَقِّ الْقَضَاءِ بِسَبِّ الضَّمَانِ. So now they get the way to reconcile this is, okay, you're going to pay. Whatever harm was done, you're going to pay for that, but we're not going to change the judgment. But because you said what you said, it was out of the judicial process now that what you're saying it, so we can't give that any kind of official position, but you have to pay, right? وَلَا يَصِحُ الرُّجُوعُ إِلَّا بِحَضْرَةِ الْحَاكِمِ. And their recanting can only be done in front of the judge, right, as well. So even if he's not the same judge, if there's another judge and they do this later, because for them to cancel their shahada, that's annulling it. Remember, this is something formal. So فَيَخْتَصُّ بِمَا تَخْتَصُّ بِالشَّهَادَةِ مِنْ الْمَجْلِسِ وَمَجْلِسُ الْقَاضِي كَمَا فِي الْهِدَايَةِ. So they're going to have to go and retract officially if they want to do that, to set their record right in front of the judge. So the judge will listen to their retraction, but the original case will not be cancelled, at least not in the normal default case. Some cases it will be cancelled, but not in the default case that we just discussed right now.